Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay. How is everybody? Hello, Texas Brat. Hello, Rockstar 60. Roz 805. Hello, Rainy. Your latex spouse. Holding down the fort along with Tater Bug and Murder by Maestro, my wonderful moderators. Thank you so much. Well, it was an epic day in court today when Karen Reed's hired gun, one of them from Arca, Daniel Wolf, the more devoted, the one who deleted all of his text messages. He just can't find them and is talking on an encrypted app, the Signal app, with his text messages set to auto delete. Has anybody been on Signal? I would love to know if when you sign up to Signal, if auto deletion is the factory setting on that app. I would think that you would have to set it to auto delete, but I've never used Signal. Let me know if you've used Signal. He says, I just strangely, my text messages were set to auto delete when I downloaded this thing. So, I mean, they were making sure that the Commonwealth never got a hold of their communications, which only shows at the least, an intense bias towards the defense, a want and a need to cover up what they're saying to each other. So anytime you have anytime you have this kind of secrecy, and I'm not talking for reasons of privacy, because this is not reasons of privacy, means that you are covering up something. I think a fair-minded juror could come to the conclusion that the defense has been up to some illegal shenanigans, or maybe let's just call them shenanigans. Leave it to the courts to decide if they're legal. Certainly, the courts have already admonished publicly the defense team for doing the same strategy I keep talking about time and time again on this channel, which is the defense withholding their discovery from the Commonwealth, ambushing the Commonwealth, making sure that they don't know what the defense is going to do in court. Now, if the Commonwealth had done this, it would be declared a mistrial. Karen Reed would walk. But because it's the defense, they get an admonishment and they're told to stop with these false representations, all these euphemisms for lying to the court. And then they do it again 20 minutes, 40 minutes later in court. And they keep making false representations to the court, i.e. lying, what normal people call lying, what us non-lawyers call lying, right? So here we have Daniel Wolf coming in answering a new claim, why he also gave false testimony. He overstated to the court how many times he had testified in trial. He said he testified in 20 trials. How he thought depositions were the same as trials. How many times have you testified in court? He's like, oh, I thought that. How would an expert witness, if he really testified as many times as he said in trials, how would an expert witness confuse depositions with being in court? They're like being in court. You're sworn in that way, but you can't confuse being in a conference room with being in a courtroom. I think he was knowingly inflating his experience for the jury in the first trial, and he never cleared it up. He failed his certification test, and he said it's a really rudimentary test, and not so rudimentary that he can't fail it, as Hank Brennan put out. I was like, that's a terrible answer, that you failed it. It's not such an important test to pass as your certification test. It's not so important because it's really rudimentary, but you had trouble with it. Oh, we'll get into all of his cross-examination. Also asked about his wife, who joined the Free Karen Reed Facebook group. All of this he came under fire for. But what was more fascinating was all the new tests he had done, which seemed to prove the Commonwealth's theory. And I'm going to plagiarize my audience member who called one of his tests the arm pinata. So he's got this arm, this disembodied arm hanging. I mean, crash test dummy arm, don't misunderstand me, just hanging there. And he's backing an SUV, a Lexus SUV into it. I mean, what is that? Are we supposed to believe that? And it's not even the right weight. Just the disembodied arm isn't even the right weight. The crash test dummy was not the right height or weight as John O'Keefe. So many problems with these experiments. Never mind also that ARCA has never wanted any more evidence than what the defense gives them. They never ask for more information to come to their conclusions. They said, actually, last trial, if they got more information and more evidence, it wouldn't change their conclusions, which any juror would find, and the jurors did find very sus. Jennifer Ray, ER, said it. I'm plagiarizing ER. That's going to be my phrase. It's so perfect. Our pinata. So good, right? So we're going to look first at the direct, some of the things that came up in the direct. Hey, Andy, nice to see you. And hey, kitties. Then we're going to go into the fantastic cross-examination by Hank Brennan. So let's get into it. First, starting with the direct. So this is the kind of thing. It seemed like much of the case was trying to disprove Welcher and not prove their own case. So some of the, whoa, what is that? Yeah, there we go. Some of the criticism of Adam Lally was that he was so busy disproving the defense's case, he didn't prove his own. But I could say the same here for the defense. They have no case of their own and no opinion of their own. It's just they keep bringing up these witnesses saying the Commonwealth's wrong without making a clear case as to what did happen. So how did this evidence happen? I mean, if Proctor planted it, we're just supposed to believe Proctor is bad. They haven't even really said he planted evidence. They're just saying he's bad and was fired. But how did Karen Reed? I mean, if I were a juror, I would be thinking, okay, defense, if this is not so, how did Karen Reed's taillight get embedded in microscopic pieces of Karen Reed's taillight get embedded in John O'Keefe's shirt? How did Karen Reed's smashed to smithereens taillight happen to be all over the crime scene if there was no collision, right? It's like I always want to dance with it, right? The way Alan Jackson says it, always in threes. No collision. Well, why no collision? Then what else happened? So let's take a look at some of the evidence that Daniel Wolf, I would call him the disgraced, now really disgraced, very biased, hired gun for the Karen Reed's defense, and from the outfit ARCA, accident reconstructionist. If I didn't say that, if I buried the lead there, forgive me. It's an accident reconstructionist. Take a look.
Case.
I don't know that I relied on it. Certainly, I utilized them to have an understanding of what his basis was for his opinion and what his opinion was. Ultimately, at ARCA, we did our own independent testing to evaluate that.
So just to be clear, I'm not asking Dr. Wolf if you agreed with his opinions and conclusions. I'm simply asking, did you rely on those in order to come to your opinions and conclusions? Did you incorporate them?
Sustained is too.
Did you agree ultimately with Dr. Welcher's opinions and conclusions?
Ultimately, Alan Jackson is not a very good lawyer. He cannot operate on direct examination at all. He cannot question a witness without asking leading questions. He cannot adjust. So the difference between direct and cross is that on cross, you can ask leading questions, and on direct, you can't. And here he is just leading the witness. Eventually, Hank Brennan just gave up because he's thought maybe these jurors are going to hate me if I keep objecting. But he did object quite a bit. There's so much leading in this. And this is also, the more this trial goes on and the more, the more the defense is sneaking in dirty tricks like comments, I notice the more Hank Brennan is doing it too. It's not something I think Hank Brennan can be better than that. I don't know why he has to stoop to their level of making comments. Just ask questions. Just ask great questions. You don't need to make comments. The jury gets it. If your questions are good, the jury will get it. You don't need to make comments and wait for them to be objected to and sort of sneak in your ideas that way. So even though it's been sustained, meaning the defense's objection has been sustained and it's supposed to be out of the jurors' minds, it's really still somewhere in the back of their minds. It's a kind of dirty defense trick, and I wish he would stop it.
You certainly were aware of what his opinions and conclusions were, correct?
Inform Mr. Jackson on that one.
Were you aware of Dr. Welcher's opinions and conclusions?
Yes.
Are some of those opinions and conclusions represented in your PowerPoint?
Yes.
Are some of them represented on this slide in your PowerPoint?
Yes.
Right. You indicated that this slide indicates that the location and orientation of the lacerations on John O'Keefe's right forearm and arms are consistent with the geometry and orientation of the right rear taillight, correct?
Correct.
Are the injuries to John O'Keefe's arm lacerations?
That would be an opinion for my colleague, Dr. Rentra.
Have you ever heard the phrase abrasion?
Yes.
In your opinion, are the injuries to John O'Keefe's right arm better described as lacerations or abrasions?
I don't have an opinion on that.
Okay.
The correct opinion is there are abrasions.
Slide number 2, please. Based on your review,
So this is every time I look at this witness, Daniel Wolf, I think of Patrick Bateman from American Psycho and think that somewhere after this he's going to be comparing business cards, his luxury business cards, with other accident reconstructionists. He comes across as such a practiced liar. His voir dire really brought out the way he's able to lie and smile at the same time. He is a slippery customer, in my opinion.
review of Dr. Welcher's reports and his data, what testing did Dr. Welcher undertake or conduct?
So he did, initially, it appeared that he did a static test, if you will, just demonstrating holding his right arm out adjacent to the rear taillights on the right side of an exemplar Lexus to demonstrate his theory of how the arm contacted the taillight.
What is a static test?
So I'm sustaining that. Ask it differently, Mr. Jackson. And I'm going to strike that.
What testing did you note that Dr. Welcher did with regard to this particular photograph? What is a static test?
Well, in a static test, that neither the arm or the vehicle is moving. It's just he's aligning his right arm adjacent to show how his arm aligns to the geometry and the dimensions of the Lexus.
Did Dr. Welcher appear to be wearing similar clothing as John O'Keefe was wearing on January 29th, 2022?
Yes.
Is there any...
They criticized Dr. Welcher for wearing similar clothing, but look at how the crash dummy is dressed. They dressed the crash dummy up in John O'Keefe's clothing, including the Nike sneakers, right down to the same make and model of Nike sneakers. So I thought this was one of the more damning tests. I mean, a jury could conclude that the Commonwealth could be right looking at this test. Check this one out.
significance or purpose for that, in your opinion?
In this test, no.
Did you identify any limitations with regard to this sort of testing undertaken by Dr. Welcher?
Well, it's very basic in that the only thing that this demonstrates is that you can get your right arm to align with the taillight. Beyond that, it doesn't tell you anything with respect to what happens to the arm when it makes contact with the taillight, right? What's the motion of the arm? What's the damage to the taillight? What's the acceleration of the arm? What's the forces of the arm? So it doesn't answer any of those other questions. The only question it answers is, does the arm align with the taillight?
You're aware that John O'Keefe was 6'1", correct?
Correct.
Is the only person, let me ask it a different way. Can only a 6'1" person align their arm with the taillight?
No, the arm is adjustable, so certainly people of different heights could also meet that alignment as well.
Just by pivoting your arm a little bit, right?
Sustain.
How would you describe the ability of somebody 5'7", 6'3", being able to align their arm with the taillight?
Just changing the orientation and the posture of your arm.
Thank you, Daniel Wolf, for telling us how we can move our arm, how our arms move.
Was there any scientific significance, in your opinion, of this particular test?
Again, other than just demonstrating that it aligns with it, no, nothing beyond that.
Next slide, please. What are we looking at here?
So this is an extracted frame from one of his dynamic tests in which the vehicle is moving at...
I mean, they're just reminding them of the state's case and, you know, how good it was. Please hit the thumbs up, guys. Let's let people know that we're here and live.
About 2 miles per hour into his arm, making contact with his hand, his forearm, and his elbow.
What is a dynamic test as it relates to a static test?
So that's when something's in motion, and in this instance, it's the Lexus moving at about 2 miles per hour into his arm.
Did Dr. Welcher explain what the purpose of this test was?
From what I recall, I think it was to demonstrate that when his arm makes contact with the taillight, he observed paint transfer in the general location that there were the abrasions or the lacerations on his arm.
Did he appear to paint the taillight?
He did, yes.
Do you see that Dr. Welcher appears to be wearing an orange T-shirt? Yeah.
Sustained.
What is he wearing?
Appears to be an orange T-shirt.
Is that similar to what was described as John O'Keefe having worn that night on January 29th, 2022?
Yes.
Is there any significance to wearing that T-shirt?
Not that I can think of, no.
Did you note any or identify any shortcomings with this particular test?
Well, much like the static test, again, it leaves the door open to all those questions, right? About, again, doing this at 2 miles an hour doesn't tell you anything about, well, what happens at 10? What happens at 15? What happens at 20? Right? In terms of what are the collision forces? What's the damage? How does the arm move? What would the expected injuries be, right? This dynamic test, as well as the static test, doesn't answer any of those questions for us.
Is this test from Dr. Welcher considered a force calculation?
I'm not aware of him making any type of force calculations or measuring accelerations or anything of that nature, no.
Did Dr. Welcher conduct any testing to determine whether the damage to Miss Reed's Lexus was consistent with the striking of an arm of a pedestrian?
I'm not aware of any impact testing that he did, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the damage to the taillight of Miss Reed's vehicle?
Not that I'm aware of, no.
Did Dr. Welcher conduct any testing to determine the forces necessary to cause the injuries to John O'Keefe's arm?
No, not that I'm aware of.
Did Dr. Welcher provide any opinions as it relates to the speed of the subject Lexus at the time of the alleged incident?
No, from reviewing his report and his PowerPoint and analysis, I could not find anywhere in it a specified speed or even a range of speeds.
Did Dr. Welcher provide any opinion as it relates to the forces experienced by the taillight in such an impact?
Not that I'm aware of, no.
Did Dr. Welcher provide any opinion at all as it relates to the post-impact trajectory or movement?
So it's all just reminding them of Dr. Welcher's testimony. Here is the arm pinata moving along.
The left, and you'll see contact occur between the taillight and the arm.
Okay. Can you explain for the jurors using this video what you meant by more of a side swipe or a clip?
Well, thanks for telling us. I mean, that's the state's theory, that it was a swipe or a clip. Here they're going 15 miles per hour. I mean, our arm is attached to a body. I mean, I don't know how this was effective at all, except to give you an idea of how he could have gotten his arm injury from the state. Also, but then, am I missing anything else? Oh, one more. Here's probably the worst of them. Is this one. And look at how the dummy is dressed, exactly in John O'Keefe's clothing.
Next slide. In this configuration, was the ATD outfitted with the hoodie that you earlier described?
Yes.
At the time you outfitted the ATD with the hoodie in this configuration before this test E, did you confirm that the sleeve, the right sleeve, was damaged or undamaged?
After this test?
No, before.
Before, it was undamaged before the test.
Okay. What are we looking at in this slide?
So this is still frames from the high speed. So starting out on the left here, just at contact. So the forearm making contact with the liftgate taillight, and then the upper part of the forearm and the elbow making contact, a direct hit into the quarter panel taillight. And the middle here is just after contact, and on the right is post contact.
Thank you. Next slide, please. What are we looking at in this video, or in this picture?
So this is a overall photograph depicting the taillights subsequent to this test at 24 miles per hour. I will note that there's no damage to the liftgate taillight, and then there is damage to the quarter panel taillight.
Okay. So she smashed her taillight to smithereens. I mean, do we need to go look at this and compare it to Karen Reed's taillight? Pretty similar, no? Thanks for proving the Commonwealth's case. Pretty awful. Am I wrong? Am I wrong on this? Hey, Thok, happy Friday to you. Thanks so much. So, but then the really exciting stuff comes in when Hank Brennan does his cross-examination. Let's take a listen.
You testified in direct, you shared with the jury some of the work that ARCA does. Do you remember that?
Yes.
And you had mentioned a couple interesting things, that there had been some work with the Department of Defense.
Correct. Yes.
The work with the Department of Defense, was that during your time or before you got there?
That would have been prior to my employment. Yes.
So when you were telling them about working with the Department of Defense, that really had nothing to do with you. That was ARCA before you began working there.
ARCA as a whole, yes. The work that we do, yes.
Not you.
As I said, I wasn't involved specifically in that project, no.
And you mentioned that you did some stuff, or the company does some things for the NHL.
Yes.
You didn't tell us much more about what you do. There's other things that ARCA does as far as clients, right?
Certainly.
Did you share with us that you work for lawyers and law firms?
Yes, we do.
And you do litigation, insurance companies?
Yes.
Okay. Is there any reason why you highlighted the Department of Defense that you don't do, and the NHL, but didn't share the rest of the stuff with us?
That's just some of the prominent clients that we have.
I see. You provided us a CV, didn't you?
Yes.
And that's like a resume, tells us a little bit about your education experience. You get to highlight some of the things, your accomplishments.
Yes.
You shared with us you've been the Director of Accident Reconstruction at this company, ARCA, since 2017.
No, not since I started.
You started with ARCA in 2017.
Correct, yes.
When did you become the Director of Accident Reconstruction?
I think that would have been in January of 2024, so about a year and a half.
About a year and a half ago?
Yes.
And you received your certification from ACDAR.
Yes.
Did you pass the test on both parts first time?
I don't recall if it, I think it was I had to retake, I think, the practical section in the afternoon.
Well, you would recall something like that, wouldn't you? Did you pass both parts on the first try?
Like I said, I think it was the second part I had to retake.
Well, this is a pretty important test, isn't it?
Not really.
It's your certification.
It is, but much of the concepts that are covered in it are very elementary.
Well, not so elementary. You had a hard time with part of it, didn't you?
Well, with respect to the portion that I had to retake, it's a practical exam where you have to reconstruct an accident, you have to determine approach angles, departure angles, and it can be very sensitive to those inputs. And unfortunately, if you mess up one of your first angles and you carry out that calculation.
Is everyone listening? He's basically saying that he failed his test because he got his calculations just a little off. And that if you get your calculations a little off, you come out with totally different outcomes. That's what I got from it. And that's why he failed his certification test. But it was so simple. But he just got his, if you get your calculations off a little bit. I mean, the jury has to be thinking, well, if you did that in your certification test, how do we know you didn't do that in all these tests that you did that didn't prove an accident? Sure looked like you did prove that John O'Keefe was hit by Karen Reed's 6,000-pound SUV, no?
That the whole problem is graded wrong, even if you did all of the math correct.
So we understand there's a multiple choice question part that's the easier part, correct?
I don't know if it's easier, but there is a multiple choice part.
There's a more practical part where you actually have to go out in the field and do assessments, kind of like the things that you did today.
You don't go out into the field, no.
And, when did you first take that second part that you didn't pass?
I don't recall.
You don't remember when you took the test?
No, I don't.
Suffice to say you took it again.
Correct.
And ultimately you passed both sections of that test?
Yes.
In your CV, you list your schooling and you list your degrees, don't you?
Yes.
You mentioned some of the things that you focused on in your academic experience, don't you?
Yes.
And you have publications.
Correct.
Recently, you did a publication regarding vehicle control history on Toyotas.
Correct.
Vehicle control history is data that is stored in a vehicle,
Yes.
and Toyota owns Lexus, correct?
Correct.
So you have familiarity with vehicle control history. In fact, you have a publication on it.
Yes.
In your entire resume, you only mention pedestrian collisions, or that you're involved in pedestrian-type events 3 times. Is there anything specific in your resume or your publications that show a published accomplishment, for example, in pedestrian collisions? Do you have any publications that have been peer-reviewed or published in that area?
No, I don't have any publications in pedestrians.
You write or you note in
He hasn't taught accident reconstruction. It just, this is just a typical debunking of an expert witness. But Cindy J says, I don't think he's ever been called out before. I'm sure he usually just flashes those dimples. I got the feeling he was a practiced liar. I don't know if he's been called out by his lies before. That's an interesting observation. So I put out a poll today asking if my girlfriend thinks, hey, ER, did you hear were your ears burning? We were just talking about you and your wonderful arm pinata phrase that I've plagiarized.
areas of special.
But everybody thinks Karen Reed's not going to take the stand, including me. I don't think she will. As much as she'd like to manipulate this jury and manipulate the courtroom and have control over the courtroom, I do not think she's going to take the stand, but she may surprise all of us. There was about maybe a 14% part of my audience that thinks she may, and they may be right. We don't know. She may be the big end surprise witness. We don't know.
Specialty,
But I doubt it.
and you list a bunch: accident reconstruction, human factors, EDR, commercial vehicle, AG/EDR, pedestrian bicycle accidents, nighttime visibility, and a number of others, correct?
Correct.
is there anywhere in your resume that notes particular classes that you've attended and completed regarding pedestrian collisions?
No, I haven't taken any classes in that.
You haven't taken any classes on pedestrian collisions?
No,
Have you ever taught regarding pedestrian collisions?
no,
Have you ever been a speaker in a presentation about pedestrian collisions?
yes.
Okay. Is that listed in your resume?
I don't list lectures or presentations, no.
You were asked questions about your involvement in this case. Yes?
Yes,
And you had shared with us that you, at the beginning, were working for a separate party or a third party, you said?
yes, another agency.
Another agency. And at some point, you came into court and testified last year.
Yes,
And during the time before you came in and testified, you weren't wholly independent of the defense, were you?
well, certainly before all of our testing, at the point at which we did all of our testing, report, and analysis, as I mentioned on direct, I didn't know the Commonwealth or the defense in this case.
My question, more precisely, before you testified, before you came into court and gave your testimony, you weren't totally independent from the defense, were you?
No, I mean, I had to communicate with them to be able to determine when to appear for testimony.
So you were communicating with them, yes?
Yes,
In fact, some of the time that you spent, ARCA actually billed the defense lawyer, and they paid that bill, didn't they?
eventually after the trial, yes.
During that time, you know what a sequestration order is, don't you?
Yes,
Do you think that you're under a sequestration order today?
yes,
Did you talk to anybody about any of the prior testimony in this case before today?
no.
How'd you get here today?
How did I get here today? I took a car ride over from the hotel.
Who drove you?
It was a driver. I don't know his name.
Who set up the car?
It would have been someone on the defense team.
Was it like a window, like a limo?
It was an SUV.
Was there anybody in the defense with you on the ride home?
I thought I saw him getting out of the car just like Russell, but I never saw he was around the defense's car when they were all getting out. So I don't want to assume that he was in that car, but I thought that he had ridden with the defense team. Why would they ride with Russell and not with Wolf, right?
There were 3 young ladies in the back seat. I think they might have been interns, and Mr. Woke.
You know?
Mr. Wolk, I think is it pronounced? Am I saying it wrong?
Have you discussed anything about this case before your testimony today as far as the trial?
Before today? Yes.
Have you discussed anybody's testimony in this case?
Nobody's testimony, no.
That was different last year, though, because before you testified last year, you did have discussions about testimony, didn't you?
Not with the Commonwealth or the defense, no.
But I'm asking, though, you did have discussions about testimony before you testified last year, right?
Correct, yes.
And you know what a sequestration order is, don't you?
Yes.
After you testified last year, the court ordered you to provide all of your text messages, all your communications with the defense, didn't they?
Yes, earlier this year.
And when you were ordered to provide all of the actual...
So you were ordered because the Commonwealth had gotten no discovery like they did for so many witnesses. Discovery was hidden, not provided. And so when my belief is that when the Commonwealth, so first what happened was the Commonwealth was asked to, the defense was asked to provide discovery, meaning all the communications they had with the ARCA witnesses, what they were paid, anything related to the ARCA witnesses, just like the Commonwealth has to, their reports, their everything. And they were giving this very vague report, and that's it. And the first trial, they said, we can't communicate with them because they were hired by the feds, and the Fed investigation is still going on. This is before last trial. And she's like, you can't, but you didn't. So we're going to have a voir dire. So then that's when we had a voir dire for Adam Lally before, and it was like the day before they testified, I believe. It had to be a day or two. I thought it was the day before. Correct me if I'm wrong, but very close to when they testified. Then they did the same thing this trial, and Hank Brennan's asking time and time again, provide me your reports. I can't debunk an opinion I don't have. Plus, I'd like to see the communications, and oh, we can't. It's federal, blah 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 blah. So he went and asked the feds for the information right before he was, going to start really kicking and screaming. He gets handed just a few communications where Daniel Wolf is referring to in an email, to Alan Jackson as Alan, right? And when he testified the first trial, Alan Jackson made a big deal that you weren't paid for us. You were hired by a totally different entity. Before today, you didn't ever meet me, which he never met him, but he met him via the phone or via the text message. They had already been retained. Spoiler alert, the big reveal is that they had a $23,925 bill. So they were retained and paid for by the defense. But at the first trial, they told the jury, under oath, Daniel Wolf said he wasn't being paid. He's like, he goes, this goes without saying, but you're certainly not being paid by us. Oh, no, I haven't been paid by you. So, you could say, well, I haven't been paid yet. But you know what that means. We're not getting paid. That's what they wanted the jury to think, that they weren't paid. They weren't biased. He made a big deal that the Commonwealth could have hired them. You could have been hired by the Commonwealth. He asked Daniel Wolf, meaning Alan Jackson, asked Daniel Wolf. But they didn't want you because they didn't like your conclusions, right? Right. Oh, yes. The Commonwealth is so narrow-minded. They only want to hire people that push their own theory, even when it's proved wrong, with just science, right? Just non-biased science. They were proved to be a hired gun. They were paid. And not only were they paid, they scripted their testimony. So he's like writing back and forth, like, this was great at the voir dire, Alan, blah, blah, blah. But, you may want to ask this. They're going to ask this. And, so here's Hank Brennan really grilling them on this. And so after that, after he got those few communications that proved I'm wondering if Alan Jackson had a relationship with Arca or Daniel Wolf before this in another case. That's what I'm wondering. If the defense, because it's so hard to differentiate between the defense and the federal investigation. It seems that they were both done with the aim to get the Commonwealth to drop the charges. There's a real rivalry between the Attorney General's office and the District Attorney's office in this area. So here's Yannetti, of course, also has ties to the federal office. So he went with Karen Reed and asked that there be a federal investigation. And that was really the building block of the whole Free Karen Reed innocence fraud movement. There's a federal investigation going on into corruption. So they didn't have to find any corruption. The point of the federal investigation was just to make it look like something nefarious was going on, something dirty was going on that needed investigation. Never mind that they didn't find anything and no one was charged. It's just the point, like that. It was like a means to an end, right? The point was to just get it going. So you could say there was a federal investigation, and it kept them also, it allowed them to ambush the Commonwealth because they never had to hand anything over. So what the judge said to Yannetti was like, you're telling me you're going to put up 3 witnesses? So at the time, there were 3 ARCA witnesses, is my understanding, on the defense witness list. And you're going to put up, so Judge Cannoni said to Yannetti, you're going to put up 3 witnesses that you've never talked to? Yes, essentially that's it. No defense lawyer would ever put up 3 defense, never mind one defense witness that they didn't know what they were going to say. You never risk something like that. They could get up there and say, well, our report looks like this, but, after we wrote our report, we surmised that she hit him with her car. We did this test or whatever, anything. They could say anything. And after he testified in the first trial, Daniel Wolf's wife joined the Free Karen Read Facebook. So there's so many ties to ARCA and the defense. They are essentially hired guns. The fact that they didn't want any more evidence to do their test is so telling to me, but take a listen. So this is the part. So after all this came out about them being hired, retained, and paid for, I believe Alan Jackson, Karen Read et al. Told Daniel Wolf, delete all your text messages. The defense deleted over 100 text messages. They handed over no communications between themselves and ARCA, besides a few that they had already released that started this whole hoopla and got them to be admonished publicly. I mean, it was seen as a huge violation and lack of candor with the court. So essentially, the defense over these ARCA witnesses were admonished by Judge Cannoni. Could get worse. People have talked about sanctions after the trial. I think there's not a chance in heck that Judge Cannoni, the innocence fraud judge that she is going to put sanctions on these lawyers, even though she should, for lying to the court. Every filing, they said they were non-biased, not paid for, expert witnesses. That's how they described them. And that they told the court they didn't have any communications with them before they testified. Untrue. And he went up there and lied and lied and lied. And so the Commonwealth said, Hank Brennan said, I'd love to have them, invite them in, but I need discovery. I'm not trying to bar them, but I need discovery. But he was never given any discovery. Judge Cannoni let them in to lie to the court some more, even though they were proven to lie to the jury first time round. It's like, please come into our court and lie some more to the jury.
Well, remain in communications with the defense. Did you provide those communications?
Yes, all of the records that I had at the time I provided.
Well, not the records. You know what I'm getting at. Did you provide the communications?
I provided everything I had in my possession, sir.
A text message isn't just a time and date. It's actually substance when you text somebody, isn't there?
Correct.
And when you texted, how many texts do you think you had with the defense?
From what I recall, I think it was around 50 texts that I sent.
It wasn't 100, you get 50?
Well, I think it was around 100 total in terms of back and forth, but it was, I think, 50 that I sent.
And during those texts, communications, conversations, correct?
About logistics, yes.
Did you provide the content of those text messages when you were ordered to by the court?
Well, those text messages spanned from, I guess it would have been April or so of 2024 through May to June of 2024. Ultimately, I think I received the court's order in May of this year, April of this year. So it was a year after the fact, and I had already deleted the text at that point.
How many of those text messages did you delete?
I just swiped the conversation, so it would have been the whole conversation.
Not how you did it. How many of those 100 or so text messages did you delete, sir?
It would have been the whole text chain. I didn't individually delete them. It just, when you swipe, it just deletes the text chain.
After you deleted them, did you go into the recently deleted and then delete them so they were unavailable?
I don't recall doing that.
Well, you were asked to search your records for the text messages. Did you do a thorough search to see if you still had them or whether you had destroyed them all?
I checked my phone, and I also checked with my phone carrier.
So do you know if they were still under the recently deleted part of your phone, or did you go and take that extra step and totally destroy them?
From what I recall, I did not find any of the text messages, no.
I love the way you said that. I didn't find any of the text messages. I didn't find them after I purposely deleted them. I didn't have any, after I threw my homework in the garbage and took it out to the curb to be collected, and it was collected. I couldn't find my homework. What are we talking about here? So does everybody get what happened? So discovery is just anything related to the case that they've done, all the work that they've done, and their payment history, their invoices, their communications. This is something that the defense team has hid. And then, so they told him to delete his text messages, I believe, because I believe it's too much of a coincidence that every defense attorney, all their defense attorneys, there's not one text message between the ARCA witnesses available to hand over to the Commonwealth after they were publicly, admonished in open court by Judge Cannone. I believe they said delete your text messages and download the Signal app, and we'll communicate from Signal, and put your Signal app, which is an encrypted app, often used by criminals, and now used by these criminal team of criminal defense attorneys. Put it on auto delete. So as soon as we text each other, it will auto delete. And that's what he did. And so there was nothing to hand over. They were free to ambush the Commonwealth. And this is the kind of nonsense that's gone on right under Judge Beverly Cannone's nose. Like she as a former defense attorney herself, it's not like she wasn't suspicious. She was very suspicious the way they were saying they hadn't had any communication with these defense witnesses. But she accepted the lie, right? And she let it happen. So, and then when it was discovered, she started shaking and she called off court for the day and said it could have grave consequences. Also, another part of this is that Karen Reed was asked at that point, because when the defense attorneys are shown violating the law of the land, they're shown not to be very good attorneys, and she could appeal. And Adam Lally also warned Karen Reed in a filing about this before last trial, that she's not getting very good representation because they're violating the laws of their profession and the laws of the land. So Karen Reed was asked privately if she wanted to keep her attorneys. She said she did. But I believe that what comes next, logically, is that you're going to have a hard time appealing because you've been warned. Let it be known that it's on the record that you have been warned, that you cannot appeal on. You have been warned many times that your attorneys are not following the rule of law, and you cannot appeal on inefficient assistance of counsel, meaning they didn't represent me well, my attorneys. And she said, I know, but I believe that they are setting up a lessee who's never tried, who's the pro bono lawyer from New York with the black curly hair and the incredible boring and over enunciating demeanor in cross examinations. I believe that they're setting him up for the fall, so that if she gets convicted, even of a puny charge, they will appeal on inefficient assistance of counsel, and he'll be the fall guy.
Is there any reason why you deleted all of your text communications with the defense?
Well, it's something that I routinely do. I work with attorneys and clients all the time, whether it's appearing for trial or inspections, and I don't have a habit of keeping a text chain that talks about logistics and things. It's just I routinely delete them after that communication is over with, and certainly after the prior proceeding, once it had concluded, there was no reason for me to preserve those.
Okay. And so, at some point, you switched from text messages to another form of communication, didn't you?
Yes, earlier this year.
Can you tell us a little bit about this new form of communication, not text messages?
Mr. Jackson had indicated that he and his defense team utilize an application known as Signal for their communications amongst their defense team. Ultimately asked if I would also use that application to communicate, which I agreed to.
Is Signal an encrypted app?
It's a secure encrypted app, yes.
It doesn't leave any records, right?
I don't believe so, no.
Well, you're using it. Do you have any records from your Signal use?
I'm going to allow that.
Do you have any records from your Signal use?
I do not, no.
So you know full well that Signal as an encrypted app leaves no record.
There may be a setting that you can change. I just know that the way that it was set up, there was no record.
Well, who set yours up to have no record?
I don't know. I think it was default.
She can always appeal, and she can appeal on inefficient assistance of counsel. It's just on that issue they put it on the record that she has been warned and offered and given a chance to get new representation. So if you go back to one of my lives at the time, ARCA witnesses exposed for, defense exposed for lying to the court around that time, around February this year. If you go back to my live streams, you can see exactly where it happened. Go to those live, those hearings that I live streamed. Maybe we'll look at them this weekend.
Have you ever checked your Signal app to see if you have any record of your communications pursuant to that court order?
Well, I don't have the application anymore, but at the time I did check the application.
Out of all these clients that you've had, how many times or how many clients would you use Signal with?
This was the first time.
Have you used it since with other clients?
Not yet, no.
Not yet. Like he has plans to use the Signal app. Like any other clients would find that wouldn't find that shady and shifty. Like, let's talk on the Signal app. For what reason? My king of kings, he strung up a fake arm like a piñata, and he thinks that's equivalent of fully grown man. So right on. I don't know if I read that before or just read it to myself, but there it is again. Excellent comment.
Before you testified last time, at the last proceeding, or should I say when you testified at the last proceeding, kind of like today, you attempted to portray yourself as totally independent, didn't you?
Sustaining that.
When you testified at the prior proceeding, did you attempt to portray yourself as totally independent?
Yes.
The truth is, before you testified, you were communicating with the defense and attempting the best you could to assist their cause, weren't you?
I wouldn't characterize it that way.
So before you testified, you wrote out questions that you thought could help, that you should be asked when you testify, correct?
So something I routinely do before testifying is prepare an outline of topics and questions that would best help be able to get out my opinions and the analysis I undertook, ultimately so that you all have an understanding of what I did.
So I'm asking you a question. You gave the explanation, but you're skipping over the answer to my questions. So
Sustained.
I'll ask you again. Before you testified, did you write out a list of questions that you wanted to be asked?
Yes.
And when you listed out the questions, you also listed out the answers, didn't you?
A general response. It wouldn't be verbatim to that.
And it's great because you listed out the answers to each and every one of the questions that you had prepared.
Yes.
So for every question, there's an answer that you provided so that you could follow a script, so to speak, yes?
I wouldn't characterize it as a script.
One of the questions asks, so not being able to inspect vehicles is something that's not uncommon in your line of work? And your answer, absolutely not. Remember writing that out?
Yes.
And then you put a footnote, a comment. And you said, not sure if you want to put this somewhere in direct examination. I have a feeling they are going to argue I didn't personally inspect the vehicles. I had enough information from the material I reviewed, so it wasn't necessary. Need to show the jury it doesn't matter in this case. You write that?
Yes.
When you're talking about they, I have a feeling they are going to argue I didn't personally inspect the vehicle. Who's they?
That'd be the Commonwealth.
And so when you were writing out these questions as is your routine with the answers, is this the mark of independence to you?
Well, I think, again, whether the Commonwealth asked me that question or the defense asked me that question, my response would be the same. It wouldn't change depending on who called me to testify. There are a number of cases, by the time I get involved, the evidence is gone from the roadway, the vehicle is gone. So it's certainly not necessary to inspect a vehicle. And I wanted the jury to have an understanding that because I didn't physically inspect the vehicle, it didn't affect my analysis in the case.
So you think that showed independence?
Yes.
Then you also had another question. Would it be fair to say that because you do a lot of nighttime visibility work, your cases frequently involve pedestrians? Remember that?
Yes.
And you said, yes, unfortunately, there is a direct correlation between time of day and pedestrian fatalities. Is that true?
Correct, yes.
And they happen more often in the day or at night?
More often at night, yes.
Statistically speaking, by the way, this case involves nighttime, doesn't it?
Correct.
Statistically speaking, most of pedestrian fatalities occur during the evening and night hours. So my specialty in the area of lighting and human factors results in a lot of my cases involving pedestrians. Did you write that?
Yes.
In fact, you testified, you shared that with the jury, didn't you?
Correct. I've testified to that twice last year as well as this year.
And in the notes that you wrote, when you shared it last year and this year, was it an important point to the jury?
I think so, because it helped gave them an understanding, I think, of my background in lighting and human factors. And as I mentioned earlier today, there's a direct correlation between time of day and pedestrian impacts, right? So my specialty in lighting and human factors results in me seeing many, many different types of pedestrian impacts.
So if it's important, why did you include a note? If you don't want me to say this, that's fine. Why did you include a note to the defense that if they didn't want you to say something that you thought was important?
I thought that was the greatest, one of the greatest owns of the day afternoon. Just a small one, probably one that most people overlooked. But I thought it was so telling. He's like, well, I just wanted to make sure the jury could understand this very important fact. And then Hank Brennan comes back, well, if it's such an important fact, why did you tell the defense that if you don't want him to inform the jury of this important fact, you won't? And now he's caught. He's really caught. Here's an interesting thing, just zigzagging a little bit from X. Karen Reed, this is from Jams on X. Karen Reed used to say that it was impossible to break a taillight with an arm. Take a listen. But then they would also say you can't. They also have argued to me, free Karen readers, that you can't break this kind of plastic. It's break proof. But then they say that she broke it, love tapping John O'Keefe's car at 5:07 a.m., making her own Ring camera evidence to replace the Ring camera videos that she deleted, or someone deleted. We think she may have deleted them. I do.
And they chose to present to the court and to the public in a hearing that those federal materials, 3,000 pages, were 90 to 95% consistent with their theory of the case. The theory of the case is a car accident. The federal materials included a report that said there wasn't a car accident. That's the case. That's 95% of the case. And it was inconsistent. It wasn't just inconsistent. It was diametrically opposed to the Commonwealth's theory of the case, or lie of the case.
You have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand.
So you literally built a cannon?
Yeah, it's pretty awesome.
Now Mr. Lally has in his possession another thing from the feds that we didn't have access to. The federal investigators hired, independent of us, we had no idea, and independent of the Commonwealth, hired a professional reconstructionist, 3 PhDs, to look into exactly this issue. Did Karen Reed's car, did her SUV make contact with John O'Keefe? And their conclusion to a person was his injuries were inconsistent with the damage on the car. The damage on the car was inconsistent with having made contact with John O'Keefe's body. In other words, the car didn't hit him, and he wasn't hit by the car. Period. Full stop. That's their independent expert, not ours, not somebody on our payroll like Mr. Whiffen or one of their experts.
Except it was on their payroll. Here's a perfect example of him lying to the court. They were retaining and paying for him.
Or Trooper Guarino, who's an arm of the agency. This is an independent federal government witness or series of witnesses who say unequivocally that car did not hit John O'Keefe, and John O'Keefe was not hit by that car.
And there's today's experiment for those listening on podcast. Just to give you an idea once more, there it is. It seems like it proved pretty nicely that there was some kind of collision. There's her there's her taillight getting smashed to smithereens. Okay. So back to our lying witness. Here's some more of Hank Brennan's fantastic cross-examination.
You would leave out.
Well, I think because I didn't want to confuse the jury about a statistic that just because we have inclement weather and dark lighting conditions, it doesn't automatically equal a pedestrian impact, right? We have to look at the evidence and the damage to the vehicle and the injuries to determine whether or not a collision occurred, not the visibility.
So you weren't trying to mislead the jury, you were trying to help them because they wouldn't understand something that you were trying to explain? Is that the way you're phrasing this?
I think at the end of the day it was to help them understand my background, how it relates to seeing a lot of pedestrian impacts.
I don't think it was important. It helps the jury get to the truth. Why would you offer to leave it out?
Well, I didn't leave it out.
No, but you offered to. You would have requested. Why did you invite, why did you invite somebody else to interject in your independence and guide you to leave something out? Why would you even provide that invitation to them?
Again, it's because I didn't want them to get hung up on a statistic that just because we have more pedestrian impacts at night and in bad weather, that this alleged incident happened at night under bad weather, to give it more weight, to weight the evidence more because of that statistic.
You done?
Yes.
Why share that statistic at all if you don't want the jury to give it any weight? I mean, why mention it at all if you don't want the jury to give it weight? Why even mention it to Alan Jackson if you don't want? I mean, he's such a terrible liar. He's the same kind of liar as Karen Reed is. He makes up lies that sound good at the moment and doesn't think about the implications or the totality of what he's talking about, you know, the whole picture. So for those that are listening on podcasts, so after Alan Jackson said, you know, this isn't our witness, this is a totally hired, paid for by another agency, said there was no, John O'Keefe wasn't hit by the car and the car didn't hit John O'Keefe. No collision, no collision, no collision, essentially. They showed the ARCA new experiment with their crash test dummy, not the right height or weight, but never mind that, dressed up in John O'Keefe's clothes and shoes, not belonging to him, but the same type of clothes, jeans and Nike sneakers and the same kind of light hooded sweatshirt he had on, or I don't know, t-shirt, hooded t-shirt, long sleeve. That's not a t-shirt, long sleeve shirt, hooded long sleeve shirt that he had on. Getting hit, getting clipped in the arm and smashing by a SUV and smashing Karen Reed's or the SUV's taillight and smashing his arm and being turned around, just as the Commonwealth's theory states.
If you make a mistake in court under oath, would you take the affirmative step on your own and correct that mistake?
I'll allow it.
I would do my best to do that, yes.
Well, when you say do your best, would you do that if you became aware of it?
I'm gonna allow it.
Yes.
Before you testified in a proceeding last year, there was a hearing that you testified in front of Her Honor and other people that were here, correct?
Correct.
I wasn't here.
No.
You were.
Yes.
And you testified about your experience, didn't you?
Correct,
When you
yes.
were sharing your experience with the court, it was important for the court to have an accurate understanding of what your experience was because it was being evaluated in that hearing, wasn't it?
Correct.
When you testified to the court, you testified that you had been qualified as an expert to testify over 20 times, didn't you?
I don't have the transcript. I believe I said approximately 20 times.
The reality is you hadn't. You only testified and you qualified 11 times.
Right. Here's where he says he thinks he testified to the jury, told the jury testified in 20 trials when it was 11. So he's doubled his trial experience. And he never corrected it. He just corrected it to Alan Jackson, who never corrected it for the record. Want to thank Mskate, someone, for buying me a coffee, making this live stream possible. I want to thank Jan Kershaw. Thank you very much. She gave a donation to celebrate Wesley loves Octoberfest being totally cancer-free. Fantastic news we got. Congrats again, Wesley. Want to also thank Shelley Flynn for very generous donation, and Jen Buell And Heather Wise, thank you very much for donating to the channel. I appreciate it. If you want to donate to the channel, links are in the description of this episode. You can buy me a coffee, Venmo, or join Patreon, become a Patreon member. And I also want to thank Marie for upping her Patreon membership. And then you get content there that you can't find anywhere else. Also, great way to support this stream.
Correct. I misunderstood the question. I thought it also encompassed deposition, so I added those two and approximated at 20.
And at some point when you realized you had made a mistake in your testimony to the court, you had a chance to come back when you testified last year and fix it and clarify the record, didn't you?
Correct, which is why I provided a comment with the specific breakdown for clarification.
And when you came back and testified under oath the second time, on the record, under oath, did you clarify and fix the mistaken testimony that you had provided to State Road?
I don't recall being asked a question. No.
It wasn't whether you're being asked. The question is, did you take the affirmative step to fix the misstatements under oath that you made?
Objection. No. Sure.
Okay, thank you, Carmel O'Reilly. Says, thanks, Roberta, for the catch up. Cry.
You appreciated that you made a statement under oath that was wrong, didn't you?
Yes.
In fact, you made a note. I realized in my testimony I said about 20 times, when you asked me how many times I'd been qualified, I misinterpreted your question, which was my fault, but I'm looking at my D&T list. It's 11 trials, 7 depositions, 18 testimonies total. I'm not sure if you want to clear it up or just leave it. So
Correct.
yours?
Yes, sir.
Can you just leave it?
I'm not responsible for asking the question, sir.
Do you ever heard the terms confirmation bias?
Yes.
Do you know what confirmation bias is generally?
Generally, yes.
Do you think that you suffer from?
So just before we get into this confirmation bias, that's interesting. When he said, I don't ask the question, sir. I mean, that is a great answer for Hank Brennan, because essentially what he's saying is, I just give the client the information and I do what they want to do. But a more independent witness, right, would care more about their reputation in having lied under oath, having essentially perjured themselves, not meaning to. Let's give him the benefit of the doubt. Strangely, he inflates. I don't know how you, as someone who's testified in 11 trials, how you confuse a deposition from a trial, but okay. Maybe he thought they asked to give him the benefit of the doubt. Depositions and trials are conflating them. I don't really understand how you can do that, but okay, give him the benefit of the doubt. Wouldn't he want to go to the court and say, I misspoke, misstated, I would like to get it on the record, have a correct record, but it's too late because he's already told the jury that. Or no, that was in voir dire, right? So that was in voir dire, so he never cleared it up with the court. So wouldn't he just write a letter to the court and make sure the record is correct? It's not good for so what it shows is that it's more important for him to be a good vendor for the defense than to really, represent himself. He bows to the defense. If they want to clear it up, they can clear it up. If not, he's going to let his lie stay on the record.
Any confirmation bias in this case?
No.
Do you have any close family that supports one side over the other? Not the facts of the data, but one side over the other.
Close family?
Yes.
Not that I'm aware of, no.
Wife?
My wife?
Yes.
I don't really know what her thoughts are on the case.
May I approach?
Yes.
Okay. This is where I'm going to end it for today. But so hold on one second. How do I know that about his wife's opinion on this case and he doesn't know? Does anybody believe that? Were we all just born yesterday? I mean, he's such a liar, and he smiles when he lies. It's so creepy. How do I know that Dana Wolf, his wife, see, it says free Karen Reed since June 25th, 2024, strangely when he testified. How do I know that? How do I know his wife's opinion? But he doesn't know? He is such a liar. I just call shenanigans and BS. No way. They're all in it. They're all into Karen Reed and free game. Look at Karen Reed's face. She knows. So this is a little ahead, my Karen cam, just because there's no way to sync them. So the Karen cam is always a little ahead. There's no way to pause the Zoom meeting from the court.
You look at that document, have you seen that before?
No, I have not.
Never seen it.
No.
Take it back. You're unaware of anything that may influence you to lean one way or another?
Correct.
When you first took a look at some of the facts in this case, you had some information. Since then, you've received a lot more, haven't you?
Correct, yes.
Part of your testimony today to this jury was to provide opinions that you do not think that the holes in Mr. O'Keefe's clothes are consistent with some type of collision. Is that fair to say?
Yes.
In coming to that opinion, you relied on some of your testing that we saw in those videos, didn't you?
Yes.
And that testing involves a hybrid 3-arm, doesn't it?
Correct, yes.
A hybrid 3-arm is an arm from a crash dummy.
Yes.
That's not the technical name, but that's what it's often referred to.
Yes.
And you and Dr. Rentschler have been working together on this case, haven't you?
Yes.
You've discussed ideas and shared thoughts.
Yes.
In fact, you've worked so intimately together, you know some of the things he's going to testify if he comes to testify, you've said many times today, right?
Yes.
And so some of the data that you shared and some of the opinions overlap with each other, wouldn't you say?
Certainly, he's going to rely on a lot of that test data, yes.
When you were forming your opinion about holes in clothes and potential abrasions to somebody's skin, all of those tests, all of those that you did, were using a crash test dummy arm, weren't they?
Yes.
In your report, you cite, or Dr. Rentschler cites, 3 different sources regarding testing clothing and skin, correct?
I'm not sure.
Well, haven't you read his report?
I've skimmed it, but I don't know what the basis are for his opinions.
Did you see footnotes 24, 25, 26, 24 being skin tissue cutability and its relation to lacerations, severity, indices? Did you read that?
Let's see if there's a foundation.
No, I didn't read that reference.
Did you read 25, the book that is cited for?
Should I continue? This is kind of interesting. I don't know. Now I'm interested. Maybe I'll just finish up on this. Let's see how this finishes up. Let's get back from this. I think they're getting back from the cross here.
Ask you about this book that is cited in Dr. Rentschler's report. By the way, have you read Dr. Rentschler's report?
As I mentioned, I skimmed through it.
So in all of your preparation with Dr. Rentschler, you merely skimmed through his report? You didn't take time to read and study it?
Well, none of my opinions are based on work that he did. He's undertaking a completely separate aspect in the analysis.
But that's not the question. The question I asked you was, did you, in working closely with him, take the time to study his report?
As I mentioned, I skimmed it. I didn't read through, as you mentioned, all the references or what he cited. I didn't do that.
Did you read his report?
I did read the report, yes, but I didn't in depth go through each reference and look at what he was citing.
So you read his report?
Yes.
And when you read his report, did you see there were footnotes for a number of different propositions that he made?
I know that there were footnotes in the report, yes.
Well, on the issue of,
So someone's asking, sorry to stop this very fascinating testimony. The inside man is asking, did any of Wolf, meaning Daniel, did any of his, meaning Daniel Wolf's wife, meaning Dana Wolf's, who joined the Free Karen Read Facebook group, posts on Facebook, get into evidence, or did his lies keep the jury from seeing it? No, that will get into, I believe, I'm not sure what he was shown. I'm sure he was shown something like this. Dana Wolf joined Free Karen Read since, June. I would think it would be something like that. I don't know if it's a post in Free Karen Read or if it's something, more detailed, but I would think it's just showing that her Facebook group. He also said he was harassed from the anti-Free Karen readers, which I cannot believe that. I have a hard time believing that. I think he made that up, but I don't know. I can't know. He didn't provide any evidence of it. You would think he would.
whether or not crash test dummies should be used.
My point is, if it was shown to Daniel Wolf, it will go into evidence, and it's all evidence the jury can look at, just like the way Lucky was shown Aiden Turtleboy Carney, the blogger, who really pushed out Karen Read and her lawyer's innocence fraud talking points in his blog and on his live streams. So Hank Brennan showed Lucky Lawford, the plow driver, who said he saw nothing that night. He's changed his story so many times. He never said he saw anything, but he's changed when he was going down what streets and when, and agreed, strangely changed his timings to a defense-friendly timing right at the time that he cooperated with Karen Read's. Right when he, what is it? Is it that he got interviewed? Wasn't right when he got interviewed, right? Is when the piece came out, threatening him. And that's when, his story started to change, is when Aiden Carney started threatening him. So anyway, that Aiden Carney's piece about Lucky maybe being part of the conspiracy and all his contacts to the McAlberts. So it's a really interesting day. Jen McCabe has been totally vindicated. When I did the live stream after Jessica Hyde and Ian Whiffen's testimony and said that the alleged, which is totally untrue, fabricated 227 time search was officially dead and debunked, the Free Karen readers all got up and armed, but now it's very quiet. So Karen Read is acknowledging that Jen McCabe did those searches at 623 and 624 at the request of Karen Read herself. Jen McCabe was always telling the truth. There's never been any conspiracy that Jen McCabe has been a part of, and that Karen Read will offer no witnesses to debunk or try to debunk or provide any witnesses to say that Jen McCabe did that search at 227.
During experiments, as a basis for an opinion of whether abrasions can happen through cloth or an arm. Wouldn't that particularly interest you, since you were going to come here and testify about it multiple times in front of this jury?
I'm not sure I understand your question.
You knew you were going to come in here and suggest to the jury that you thought that these tests were inconsistent with causing any type of holes in clothing similar to Mr. O'Keefe's or abrasions on his arm. You knew that was going to be part of your opinion today, yes?
Yes, yes.
As part of forming a valid opinion that people can rely upon, wouldn't you want to do as much study as possible on the background for that opinion before you give it to a jury?
I suppose, yes.
Well, you suppose. Don't you think if you come in here as an expert, the jury is relying on your background and education
Yes.
And they're relying on the fact that you're representing something definitively?
Really? The witness has to confirm for it to come in, Annette? Is that right? What's that based on? Explain the logic to me of that. I'm not saying you're wrong. I'm just curious.
Or with an opinion to a reasonable degree of certainty? You understand that, right?
Yes.
And don't you think when you do that, that it's important that you have proper study and foundation before you just come into court and give an opinion?
Well, I will note that the ATD crash dummy is a generally accepted test device to use for not only assessing occupant forces in motor vehicle crashes, but also to assess impact forces. So that the use of that device is certainly generally accepted.
When you get uncomfortable with my question, you generally tend to answer a different question.
Sustain, Mr. Brennan, next question. Strike that, Jules.
Let me ask you again. Do you think, as an expert, it's important when you come in, and you're going to present an opinion based on science or engineering or whatever you want to do, that you study the basis for that opinion before you give it?
Yes.
When you saw and got
Oh, darn it! Sorry, guys. I'll find my way back. So he can't come in if he hadn't seen it. Are we supposed to believe he hasn't seen his wife's Facebook post? Really? All right. I'll find where we are. Sorry about that. Sometimes it just happens on a live stream. I may be the only one who does it, though.
The agency that retained us didn't ask us to do specific work per se or specific tests.
You didn't do any type of crash test at that time, did you?
Not like was demonstrated today, no.
Instead, you started a working theory that perhaps a glass was thrown at the rear taillight of the defendant's car?
Yes.
Thank you, Donna Marie. I appreciate it. Thanks very much for supporting the stream. I appreciate it.
Did someone suggest to you that was a theory?
No.
It's just something that you and Dr. Rentschler thought up together?
Based on the evidence that we had, yes.
When you thought up that as a potential theory, that's why you built the potato cannon?
The pressurized cannon, yes.
Pressurized cannon. And you shot a glass at the rear taillight, yes?
Yes.
You determined that at 37 miles per hour there'd be similar damage?
Yes.
And then you came into court last year, didn't you?
Yes.
And you provided that opinion of consistency to the jury, didn't you?
Yes.
You got up and you said that something to the effect that that speed is consistent with the damage?
Yes.
Now, when you gave that theory last year to the jury, did you know about other evidence in this case? For example, if a glass was thrown at the back of the car, how would the bottom of the glass bounce off the car and land near Mr. O'Keefe's body?
Ask it differently.
Did you consider, when you came in last year and opined, gave your theory about a glass being thrown at the taillight is consistent with damage, did you think about how, if a glass was thrown at the rear taillight, the bottom would have bounced off the vehicle, wherever it was, and landed in the air, Mr. O'Keefe's body?
I'm aware that it was found near his body, yes.
And knowing that it was found near his body, you knew his body was about 7 or 8 feet off the road, didn't you?
Yes.
Knowing the bottom of the glass, the broken glass was found near his body 7 to 8 feet off the road, did you consider if somebody threw a glass and broke that taillight, cross your mind, how would the bottom of the glass bounce with him to where his body ended up?
No, I did not analyze that part of it.
If a glass was thrown and bounced off that car, did you consider how would Steve would be left in the car?
No, I did not evaluate that.
If glass was thrown at the car and broke the taillight, did you consider how the debris field would end up on the lawn?
Well, it's my understanding, I think that there were plows that came through that night, so I don't know that where the debris field was eventually found, if that's where it would have been at some point earlier.
Did you ever talk to Lieutenant O'Hara or anybody from the state police to see if the plows went all the way to the side of the yard or were just down the middle? Look into that at all?
No, I did not.
So did you give any careful consideration to if the glass was thrown and hit the back of that taillight, how would be a debris field on the front lawn of somebody's yard?
I don't think that was a part of our scope. It was more or less to determine whether or not, if the taillight was impacted by a projectile like a glass, could you get generally consistent damage to that taillight? That was the objective of the test.
So when you came in and testified last time, you weren't considering all of the other evidence that may not support that theory, were you?
I think our objective was to determine whether or not the damage was consistent with an interaction with Mr. John O'Keefe, and could there be another mechanism to cause the tail light to break.
Is there a reason why you were backing off that opinion on direct examination today?
Sustained.
You weren't fully embracing that theory today, were you?
I'm going to allow that.
I don't know if I agree with that.
In this case, you provided reports recently.
Yes.
When did you provide your report? Was it April 6th?
April 6th?
Or was it May 6th?
I think it's May 7th,
May
if I'm
7th.
not mistaken.
So you provided a report May 7th, yes?
Correct.
And do you know when this trial started?
Early April?
You provided your PowerPoint. When did you provide your PowerPoint?
I think it would have been Thursday of this week.
Well, it wasn't last week.
Sorry, maybe Wednesday.
Probably
Wednesday or Thursday.
Wednesday. Is that fair?
Yes.
In looking at pedestrian accidents, it's important to try, if you can, understand the exact positioning of the body, isn't it?
If a collision occurred, yes.
And if a collision occurred, you can't always identify the exact position of the body, can you?
No, oftentimes it can be very difficult, yes.
You would want to know if it is a collision between a car and a pedestrian, whether the person was fully impacted or it was a clipping type incident. Wouldn't you want to know that if you could?
That would certainly affect the trajectory, yes.
And you would want to know, if you could, the body posture, whether the person was standing up straight or crouching,
If a collision occurred, yes.
whether they were turning or standing straight or they had their arm out. That's helpful information, isn't it?
It can be, but when we're talking about how quickly this impact duration is, right? If you recall back to the PowerPoint, right, we're talking about a 10 millisecond window. So however the body is positioned at contact, that's how it's positioned. It's not going to be able to have any significant movement or change in orientation in that 10 millisecond window.
The position of the body can change the trajectory of the person who's hit, can it?
Sorry, can you repeat the question?
Positioning of the body, the way they're positioned, that can change the trajectory if they're hit, after they're hit. Can it?
It can, yes.
Whether they're moving towards the vehicle or away from it would affect the trajectory, wouldn't it?
If they have some relative velocity, yeah.
Trying to determine the point of impact when you're looking at a scene, it's important when you do trajectory studies to know where the point of impact is, isn't it?
If you're going to utilize studies that look at projection of pedestrians when you're contacted at the center of gravity and you get projected some distance, you can rely on those studies, but you have to have an understanding of where the point of impact is and where the point of rest is.
You don't have the point of impact. If you don't know the point of impact, you don't know the exact body position. That creates variables in your studies, doesn't it?
Well, again, talking about those studies, they're not applicable when you are contacting, for instance, just a limb or you don't have a center of gravity hit. Those when you're talking about how far will a pedestrian get projected, if it's like a forward projection or what's known as like a wrap projection where the pedestrian wraps onto the hood and then becomes decoupled, those studies are applicable there. But when you're talking about where there's minimal overlap between the body and the center of gravity, then you can't utilize.
What is that language? So they're talking about, so what Welcher said is, the reason why he didn't do a car and a dummy, he doesn't know what the position of the body is. Nobody knows the position of John O'Keefe's body and where he was at the time of impact. So it's really hard to say where he, how he got thrown or how he moved. They can guess that he got sort of clipped on the side and turned around and, thrown. That was the first, more Trooper Paul's, and hit his head. I mean, that's always been and hit his eye on the spoiler. But we don't really know. And, what's interesting, what I'm thinking about is how he failed that exam. That is his certification exam. He's saying if you change any little bit, but now he's saying he's using the word uncoupled, that the pedestrian and the car get uncoupled. Do they get consciously uncoupled? Is this a kind of Gwyneth Paltrow divorce kind of thing? I mean, where do you get that language? Where did these expert witnesses get this language from? I mean, I think I need to play this one more time. I like to play. I think I have this here. I may not. Let me see. Do I have it? Do I still have it in here? Or did I move it out? I think I moved it out. Hold on one second. Please hold. Please hold. I think everybody knows what I'm going to play who's been following this channel for a while. But these expert witnesses, I mean, where do they get this language from? You know, consciously uncoupled. Okay, here we go. This is Dominic Dunn talking about expert witnesses.
I only cover the trials of the rich.
He was a writer for Vanity Fair, covered trials. His daughter, Dominique, was brutally murdered, and her murderer was given a very ridiculously light sentence by the judge. And that started his writing for Vanity Fair, wrote about his daughter's trial first, and then wrote about the O.J. Simpson trial, the Phil Spector trial, the Menendez brothers trial. So many big trials in California. But here he is talking about only covering the trials of the rich and famous and the expert witnesses that they have and what he thinks of them.
I only cover the trials of the rich, powerful, and famous because it is different for them than for other people, because they've got the bucks to spend on the $1 million lawyers, and they've got the bucks to bring in the expert witnesses. Jurors fall for those expert witnesses every time. I call them whores of the court because they can be bought by either side.
There, the whores of the court. Whores of the court. Perfect word for Daniel Wolf.
Utilize those studies.
So you would not want to know what the point of impact is?
In this particular case, no, I don't think it would be helpful.
You would not want to know the body position?
I don't think that it would be helpful in determining, because again, we have to start with, is it consistent with a collision?
So you would not want to know the body position. That's what you're telling us. You don't want to know that.
Well, if the evidence indicates that the contact is inconsistent, then that's kind of where the reconstruction stops. You can't go to a point of impact and a point of rest if there was no contact.
So you don't want to know the body position?
Can you answer that?
I don't understand this question, Your Honor.
When you're doing studies, you don't want to know the body position?
Can you answer that, Dr. Wolf?
Again, it depends on the type of impact. For the alleged contact in this case, you can't rely on those studies about impact location and point of rest. They're not applicable to
Let's
this.
talk about studies. As far as data, information, you as the person doing tests, would you want to know the body positioning?
And this time we'll get an answer, and that'll be it. Can you answer that, Dr. Wolf?
I feel like I've answered it the best I can, Your Honor.
Okay, next question.
You don't like that question?
Sustained. Strike. Those disregard.
Okay. When you were doing these video demonstrations, was it important to be as accurate as possible?
Yes.
Data changes if information changes, right?
I'm not sure I understand your
That's a
question.
tough question. You want to be precise as you can in ultimately having a conclusion regarding data, don't you?
Yes.
Could I have PowerPoint page 12, please? Now look at force on the bottom. The first letter, F, signifies force, correct?
Correct.
And the last two letters, MA, signifies mass, yes?
Correct.
That's a very important part of that equation, isn't it?
Yes.
If you change the mass, it can change the whole analysis, can't it?
I'm not sure I understand your question.
Let me make it more simple. When you did these tests, you chose an arm from a hybrid 3 crash dummy, didn't you?
Yes.
You can take that down, Ms. Gilman. Now, when you made that choice, you knew that John O'Keefe's arm, based on the statistics and his weight of being 216 pounds, you knew that his arm weight would be 11.8 pounds, didn't you?
Yes.
And you knew that he was 6'1" tall.
Yes.
When you decided to choose an arm in this case, you didn't choose the arm closest to his weight, did you?
It was representative enough, yes.
It was representative enough.
It was close enough, yes, sir.
Close enough. Wouldn't you want to get an arm most closely related to his actual weight?
I don't know that you can have custom-made ATDs.
But you probably can't custom make them, but they have one that's 12 pounds. You know that, don't you?
Are you referring to the 95th percentile?
Yes, I am.
Yes.
So there's a 12-pound arm. Mr. O'Keefe's is 11.86 according to the statistics. You know that, right?
Yes.
You looked it up.
Yes.
You didn't tell us that on direct, though, did you?
I don't believe I was asked that.
No. Instead of choosing the 12-pound arm, which is 0.12 difference, you chose a much lesser weight, didn't you?
It was about 10 pounds, yes.
No, it wasn't about 10 pounds. It was less than 10 pounds. Let's be exact. You're a scientist. Let's be as precise as possible when we're talking about data. It was less than 10 pounds, wasn't it?
I think according to the spec sheet, I think it's 9.4 pounds total.
How about 9.38? You keep coming up a little bit. 9.38 pounds.
Sustaining that for
May I approach?
Yes.
Showing you a photograph. Is that a photograph of your materials in this case?
Yes.
In that photograph, it shows the arm that you used in your studies, doesn't it?
Correct.
And it shows that that arm weighs 9.38 pounds, doesn't it?
Yes.
And that is less than the 11.86 pounds of Mr. O'Keefe's arm, yes?
Correct, yes.
You didn't put that photograph in your PowerPoint to make it clear to everybody you were using an arm that was a much lesser weight, were you?
No, I didn't put that photograph.
Can I move this to evidence, please?
Okay. Any objections, Mr. Jackson?
Of course, Commissioner, I'd like to show this to the jury.
Just give us a minute, let Madam Court Reporter mark it.
217.
Yes, now you can put it.
This is the arm that you used in all of your videos, right?
Correct, yes.
And you can see, could you zoom in, Ms. Gilman, on the weight? 9.38 pounds.
Yes.
There's a bigger difference between 9.38 and 11.86 than there is 12 and 11.86, isn't there?
Correct, yes.
So when you do the math, and have you done the math before on this? When you do
I had Karen Reed was so jittery today. I had such a hard time keeping her in frame in the Karen cam. She was up. It was just like I was constantly moving it to keep her in frame. She moved all over the place. It's very nervous. I mean, I don't know if it's nerves or something else. Just energy, moving around constantly.
do the math, it's 26% difference, isn't it?
So I'm going to leave it there, but let's look at Karen Reed, what she had to say about being in court today.
Karen, your opinion on Wolf, does that prove your case?
I believe so. No impact.
I mean, listen to this riffraff that Judge Canoni has let go on. The jury's going to hear all this screaming for Karen Reed. And they want it that way. They want to impact the jury. I mean, it doesn't really show confidence in the evidence to prove her innocence if you have to impact the jury. I mean, here's what she had to say.
What do you think about Brennan trying to discredit him?
I don't even know where to begin. The math is wrong. The numbers change. 26.3, then it was 23.6, and 11.68 and 9.38 is a 21% increase. So that math is a lie, and it's premeditation for a forced calculation.
She's just calling out numbers. 23, 11, 12, 14, 21, 19. It's all wrong. She said the same thing anytime there's damning evidence, it's garbage in, garbage out. I don't know if reality is setting in. She may get, like I say, I never know which way a jury's going to go. Maestro is definitely convinced that he thinks she's going to be convicted without a doubt of what, I don't know. We didn't talk whether it was murder 2 or something else, manslaughter. Certainly the evidence is there. I think for murder 1, premeditated murder, even premeditation, even if it's menace. But they went with murder 2. it carries with it a life sentence in Massachusetts, which is 30 years, which she could do. This is if, the best scenario, in my opinion. She could do, if she got convicted of murder too, she could do 30 years, and she would do 15 years for taking John O'Keefe's life. 15 years for a life, and a life sentence of grief for the O'Keefe family, and permanent trauma to his niece and nephew. 15 years for a life. So if you want to kill your loved one, go to Massachusetts. It's a great place to get away with murder, I think. All right, that's what I have for today. Please hit the thumbs up, guys. Share the episode. Support the channel. Venmo, buy me a coffee, Patreon, all great ways to support the channel. Link is in the description of this episode. Tell your friends and family about the show. And I will be back tomorrow at 6 p.m. Eastern. Have a great night. Thanks so much for watching with me. I'll see you tomorrow at 6 p.m. Eastern. See you then. Thanks for listening.
I hit my boyfriend with my car. It wasn't an accident. But with lying lawyers, I'll go far. Lying lawyers and witness harassment. I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim.